Those are live visuals coming out of the Constitutional Court where the Sexual Offences Act case is underway. Now, let's unpack those proceedings in the ConCourt with Wise Africa Director Advocate Brenda Madumise-Pajibo. Advocate, a very good afternoon to you. Thank you so much for joining us. Now, as someone who's deeply involved in gender justice, how significant is this Constitutional Court challenge for survivors of rape and sexual violence in South Africa that we've just been listening to?
Hi, good afternoon, Ms. Kakana, and to the viewers. Listen, I think this is what democracy is all about, and this is about us testing the Constitution and its robustness, right? So all the time we need to push the envelope to be able to test whether, when we talk of equality, when we talk of discrimination, when we talk of sexual autonomy, when we talk of dignity, whether those things are real for many South Africans vis-a-vis gendered violence, right? So can you, as a South African and a South African woman who's subjected to gender violence, to abuse, to rape, to sexual violence, sexual assault, can you safely talk about dignity and that your right to dignity is guaranteed and is restored even though you are subjected to these forms of violence? Can you talk about your bodily autonomy and sexual autonomy in the light of you facing sexual assault, facing sexual violence, facing rape? Can you talk about equality, living free and safe in this country when all those rights are trampled upon all the time? So it is what you have before the courts, and especially the Constitutional Court, is ready to test all of that, and for the court to declare sections of the Sexual Offences Act unconstitutional, because for the longest of time we have been placing the burden on victims and leaving the perpetrators to say, I thought there was consent. So we rely on someone's subjectivity that they thought there was consent because you agreed to go to their house, you agreed to be in the same space with them, you agreed to go to dinner with them, you agreed for them to buy you a savannah, and they took it that by doing all of that, you are agreeing that you can be violated and sexually violated.
And just coming to that analogy that you've given as well now with the current laws and as they stand, that allows an accused to avoid conviction if they believed, even unreasonably so, that there was consent. From a legal and survivor-centered perspective, I mean, why would you say, furthermore, this is so problematic?
Masa, I didn't get you. You're a bit faint. I didn't get what the question was.
I was asking, you had already touched on it in this intro answer as well, but when we're looking at the current law, it allows an accused to avoid conviction if they believed, even unreasonably so, that there was consent. Now, from a legal and survivor-centered perspective, why would you say, furthermore, this is so problematic?
So it's problematic in many ways. So let's take you to the ConCourt judgment, right? Because it was also about that. It was about a young woman who found herself in a former partner or a partner's place. They had agreed to be together, but she made her intentions known upfront of how far she's willing to go. She says, "I'm willing for us to kiss, not beyond that," right? But the partner did not think that and decided to go beyond the kissing. And in his mind, he believed that there was implied consent because there was kissing, right? So the judgment that we had from the ConCourt, which was challenged in the Supreme Court of Appeal, was that there is no, kissing or even foreplay does not mean that there is consent for sex or sexual intercourse, right? So for each and every act, there must be consent. So when I make it clear that I'm consenting to X, surely you can't decide that you are going to Y when I've only consented to X and Y I have not consented to, right? And that's that's what you have before the Constitutional Court now, because what the parties to this matter are arguing is that you've got international instruments, you've got South African law. You cannot afford to give the perpetrators the pass and talk about the subjectivity, because it's about the subjective. If they believe subjectively that they think there was consent, then they get away. They cannot be convicted, because they're going to get away to say, I subjectively thought that she consented, and the court must then know what is that. What does that? How did they see the subjectivity? What is that constituted subjectivity? So what is happening now in the court is to really help almost every single judicial officer, from the magistrate level to the High Court, to the Supreme Court of Appeal, to the High Court, to settle this matter once and for all on what is expected when you're confronted with sexual violence cases, sexual assault cases, and rape within the definition of the law. And why is it that you need to strike down those provisions that are deemed to be unconstitutional? Because once you allow those provisions to go ahead, you then have this continuous debate around subjectivity, objectivity, dolus eventualis, and dolus directus. And so it's about dealing with intention and belief. You might have belief in something, but what is the intention and the impact of that intention of your actions? So it's technical, but I think once the court has come out and whether they agree with the applicant's position, we will then know how to navigate cases of rape once they come before the courts.
And as you're mentioning subjectivity as well, do you think this will also be able to answer the question of basically whose consent or idea or perception of consent supersedes the other? You mentioned the ConCourt judgment. In the case of the Holstracher case, the court accepted that she didn't actually consent, but they still acquitted the accused because they believed that he believed that she did. So what message does that send to survivors who, for instance, freeze or dissociate during an assault?
It sent a very negative message. And I think where we're heading to, and many jurisprudence around the world are struggling, and they've been trying to perfect their laws around rape. Because remember, some of these things happen when it's just the two of us, right? So when you go before a court, the credibility of one person is going to be compromised. And most times it has been women, the victims themselves, who are not believed, because we live in a world, and especially in this country, where we minimize and trivialize the harm that is inflicted on women, right? We trivialize it, we ridicule them. So it sends a negative message when that posture is taken. And that's why we have to then rely on the courts to give us a proper interpretation, so that there is no confusion, there are no blurred lines, there's no gray area. We know exactly what we are looking for once a matter of rape, of sexual violence and sexual assault comes before the court. And we derive that from the act itself. And if you are going to strike down the provisions that the Constitutional Court is being asked to strike down, possibly you start to have a much clearer approach. What the Center for Applied Legal Studies, whose amicus, or is the third applicant in this matter, they're actually looking for a radical approach where you literally stop thinking or even wanting to rely on the versions of the victims themselves, and you want to burden them to be the only ones who must be able to show that they did consent or did not consent, and you leave this other party who wants to claim that they thought there was consent, and it's left at that, and they can go scot-free.
Advocate, always a pleasure to get your insights. Really appreciate your time. That, of course, is WISE Africa Director, Advocate Brenda Madumise-Pajibo.